The concrete trucks are banking up, the supervisor is pacing, and the principal points to an unmapped utility line and tells you to just deal with it and add it to the next claim. You shake on it, and in that moment, you've traded real money for a verbal promise. Here's how to protect your payment under the Building Industry Fairness Security of Payment Act 2017, the BIF Act. First, send a written variation notice within 24 hours. Verbal side instructions rarely survive adjudication under the BIF Act, so paper the change before the next progress claim lands. Second, get it in writing before work starts. The Queensland Building and Construction Commission Act 1991, the QBCC Act, generally requires variations to be documented in writing before commencement. Non-compliance can attract penalties of up to 20 penalty units for domestic building contract variations under Schedule 1B Section 40 and up to 80 penalty units for building contracts including commercial contracts under Section 67G. Third, cross-check every renegotiated payment clause. Extended payment terms and pay when paid clauses are statutorily void in Queensland, so a poorly drafted deed of variation can strip away the very concession you negotiated. Under Section 67W of the QBCC Act, any provision in a commercial building contract requiring payment later than 15 business days after submission of a payment claim is void. Under Section 67U, the equivalent cap for construction management trade contracts and subcontracts is 25 business days. The applicable threshold depends on where your contract sits in the contractual chain, so confirm which cap applies before signing any renegotiated deed. And fourth, protect your adjudication rights at signing. Any clause asking you to waive your BIF Act rights in exchange for variation approval is unenforceable, but only if your underlying variation paperwork establishes a clean contractual entitlement to begin with. Securing your right to payment takes rigorous administrative discipline at the moment the instruction is given. This information is general in nature and does not constitute legal advice. For advice tailored to your circumstances, get in touch with our construction law team.